This is the last topics, okay? The agency versus loan, okay? We start first with the agency versus loan. Okay, of course, alam nyo na kung anong agency, paulit-ulit. Okay? Okay? Isa-isayin natin. Where money advanced to another is expressly regarded as money lent, walang agency. So, ang ibig sabihin nito, kung yung money, yung pera na in-advance sa iyo, okay, is considered as utang, it is not classified or it will not result to a contract of agency, but it is one of a loan. Okay? Because the one who borrows is the so-called borrower. It is not the agent, but it is the borrower. Borrower or the debtor. But in a contract of agency, the person is an agent whom you will or will not pay. Okay? So, the one who borrows money to conduct a business in which the lender has no interest or concern in the manner of its conduct is not an agent but the lender. Okay? Lagi nyo rin tandaan na in an agency, okay, an agent may be given funds by the principal to advance the latter's business. Pwedeng bigyan po ni principal si agent ng pera, okay, to advance yung business ni principal. Okay, syempre, always the principal's interest. However, in a loan, okay, the borrower is given money for the purpose of his own, okay, and he must generally return it, okay, whether or not his own business is successful. How about in a contract of lease? In a contract of lease, okay, in a contract of lease, remember the difference between a agency and lease of service is that in agency, the basis is representation. Di pa paulit-ulit natin yan. While in a lease, the basis is employment. Okay? Another one, in agency, the agent exercises discretionary powers. While in lease of service, the lessor ordinarily performs ministerial functions. Okay? And another difference is that in an agency, there are usually two persons involved, the principal and agent. Okay? But however, you may also include another person and you call that the third person. However, in a contract of lease of service, there is only two person. Okay? And that is the lessor and the lessee. Okay. Another one, okay, is your independent contract. Okay? In agency, distinguished from negotiorum gestio. Negotiorum gestio is one of the quasi-contract. Diba there are 5 sources of obligation. Your law, contract, quasi-contract, delix, and your quasi-delix. Okay? Quasi-contract, there are 2 forms. Solution indemnity and your negotiorum gestio. Okay? Negotiorum gestio as distinguished by agents, as distinguished from agency. Okay? In both agency and negotiorum gestio, okay? Before that, ano ba itong sinasabi ni ma'am na negotiorum gestio? Naalala ko to pero hindi ko na alam ko ang ibig sabihin nito. Tatagalog ko. Ang negotiorum gestio is isa pong form ng quasi-contract. Okay? Bakit quasi-contract? Okay? Quasi-contract kasi wala talagang kontrata, kasi walang consent. Diba? One of the 3 elements of a contract is consent. Consent, object, and consideration. Walang consent sa quasi-contract. Tandaan nyo yan. Bakit siya quasi? Anong ibig sabihin ng quasi? Parang. Itagalog ko, parang kontrata, pero saan talaga? Jai. Nya. Ang negotiator gesture is a quasi-contract. Okay? And a negotiator gesture in English term is the management of business or affairs of an absentee. Okay? There is representation. Example, nasunog yung bahay ng kapitbahay ko. Kung hindi ko papatayin yung apoy, is masusunog din yung bahay ko. Anong gagawin ko? Yung kapitbahay ko andun sa abroad. Hindi niya na-check na naka-on pala yung, let's just say, yung gasol niya So, matagal na palang naglilik yung, example lang, exaggerate ko lang. Naglilik, ganyan, tapos nag-spark. Di may fire na. So, there's a fire. Kung hindi ko papatayin, masusunog din yung bahay ko. Now, I have now the obligation there is an obligation on my part to preserve the properties. Okay? So, there is now a management on my part. You call that negotiarum gesture. May consent ba? Wala. May object? Meron. Okay? May consideration ba? Wala. Wala din also. Pero, it will benefit me also because of the danger in my property. Okay? In that case, there will be a management of the business or affairs of the absentee. So, in that case, is that similar to agency? It is similar to an agency in a sense that you will act on behalf of another person. Okay? But that person is not my principal. It is only my kapitbahay. Okay? It's only my neighbor. Okay? So, in negotiarum gesture, there is a lacking of a contract, lacking of elements in a contract, that is your consent. Next one is your agency distinguished from brokerage. Okay, what is brokerage? Ano ba sinasabi ni ma'am na broker? Ano ba tong broker at saka brokerage? Ito ba yung nakikipag-break sa isang relasyon? Ito ba yung break na tayo? Ganun ba yun? The answer there is no. This is a legal term. Okay? A broker is one who is engaged for others, okay, on a commission. Okay? Usually, nangyayari ito sa mga lupa. Okay? May broker. Give po sila ng 10% of the total sales. Okay? So, he is a negotiator between other parties. Always, okay, this person is never acting in his own name. Never. Okay? Acting in his own name, but in the name of those who employed him. Ano naman ang brokerage? Ang brokerage is a term referred to the trade or occupation of the broker. Okay? So, anong difference nito dun sa agent? Okay? The brokers are usually classified in accordance with the types of the property. Okay? It can be a estate broker, or you can be an insurance broker. Yan. Okay? Let's proceed with sale. Of course, you know that there are lots of differences between agency and sale. But I'll just give you the most important. Okay? In an agency, okay, of course, there are two parties. Generally, the principal and agent plus the third person. However, in a sale, there is the seller and the buyer, or the seller, buyer, or the pwedeng merchant, okay, or the buyer. In an agency to sell, the agent receives the goods or property as the goods of the principal, okay, while in a sale, the buyer receives the good as the owner. So, in an agency to sell daw po, yung ahente, tinatanggap niya yung property, okay, as the goods of the principal. Pero sa isang sale, yung tumatanggap ng property is you call that the buyer. And upon acceptance or upon receiving the goods, you are now considered as the owner of the property. How about in a bailment? Ano itong sinasabi ni ma'am na bailment? Okay. Always remember, okay, there are two other essential characteristics of agency that are not present in bailment. Alam nyo na yung characteristics ng agency, di ba? So, ano yung mga characteristics ng isang agency na wala sa bailment? Okay, number 1, the bailee is possessed of no power to bind the bailor in personal liability, and he owes neither loyalty nor obedience to the bailor. A bailee, however, may be constituted an agent as to third parties. For example, he is vested with ostensible authority to sell or to make binding contracts with respect to the subject matter of the bailment. Okay, lastly, how about the guardianship? Okay, in a guardianship, okay, the distinctions are the following. I'll just give one na lang. Okay, while the agent derives his authority from his principal, okay, the guardian, although he acts for and on behalf of his ward, does not derive his authority to act from the ward. Ito, lagi niyong tandaan, okay, that in a guardianship, you always apply. Pwede kayong mag-apply judicial or extrajudicial. So, nangyayari ito madalas sa mga rich kid. Hindi naman all the time, pero nangyayari ito yung mga naulila, wala pong parents. Okay? If their parents are already absent or are already dead. Here, the ward can apply through the help of the SWD or through the help of the courts. Okay? Pero yung contract of agency, hindi mo kailangan pumunta sa korte para mag-apply na sabi ni principal, kailangan ko po ng agent. You don't need to go to courts to have an agent. So, next one, agency distinguished from trust. Okay? The essential distinction between a trust and agency are ordinarily in the fact that in a trust, the title and control of the property under the trust instrument passes to the trustee who acts in his own name. Okay? Pero sa isang agency, yung agent po represents and acts for his principal. And in further fact that while a trust may be ordinarily be terminated only by the fulfillment of its purpose, an agency may be generally revoked at any time. Ang ibig sabihin nito, sa trust, matatapos yung relationship upon the fulfillment of the purpose of the contract. Pero sa isang agency, anytime pwedeng i-distinguish. Bakit? Kasi po, it's fiduciary relationship by trust and confidence. Kung naging doubtful na si principal sa'yo, pwede niya nang i-revoke at any time. Okay? And last one is the agency versus judicial administration. Okay? So here, the provisions of law on agency should not apply to judicial administration. Okay? Who is a judicial administrator pala? A judicial administrator is appointed by the court. Okay? He is not only the representative of the court, but also of the heirs and the creditors of the estate. So here, it is only the agent, okay? The agent is only answerable to his principal as compared to a judicial administrator. Okay? The protection which the law gives the principal in limiting the powers and rights of an agent stems from the fact that control by the principal can only be through agreements. Okay? Whereas the acts of judicial administrators are subject to specific provisions of law and order of the appointing court. Okay? Yun ang difference niya ng agency sa judicial administration. Okay? Ang judicial administration, always with the supervision of the court. Ang agent always the supervision of the principal. Yan. So,